slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that, spitting slow, speaking fast. I could roast, I could gas, think I'm okay at last, but I don't know if that can erase all the past and the pettiness. A reflection of the emptiness, hilarious. You think you're worth my time, you're delirious, mysterious, because you are behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah. Now that I've been put through, I've never got anyone's help.
Hello everyone. How are you? I hope you're well. Sorry about last night. I spent the day before yesterday and the day before that cutting grass, and I cannot do stuff like that. I was in so much pain. I could not get out of bed. It was so bad. But here I am. Ice and rest helped. So anyway, let's see. Today we're talking about Lori, of course, Madeline Kingsbury, of course, Bryan Kohberger, and Cody Bigsby's dad. Let's talk about him first, shall we? He now has been charged with Cody's death. And this is the grand jury indictment. The grand jury charges that on or about June 18th, 2021, in the said city, Corey Jamar Bigsby Sr. unlawfully and feloniously did kill and murder Cody Bigsby in violation of 18.2-32 of the Code of Virginia, 1950, as amended. And then it has witness sworn in court and sent to the grand jury to give evidence. A true bill checked off, the foreman and the clerk, dated June 5th. So, you guys, they're saying that Cody was missing June 18th, 2021. That's when they assume he was murdered. So, I don't like all these odds and stuff. Court documents. Father accused of killing Cody Bigsby months before 4-year-old was reported missing. A new grand jury indictment alleges Corey Bigsby not only killed his son Cody Bigsby, but did so months before he was reported missing from Hampton on January 31st, 2022. That's when he was reported missing. Hey, Kaz, my lovely. He was reported missing on January 31st, 2022. But yet, law enforcement believes he allegedly murdered him June 18th, 2021. Half a year he was gone and not even reported missing or anything. I guess that's what you have to do to make sure the body's never found, huh? Bro, I can't stand people like that. Okay, let's go. The alleged murder happened, okay, I said that. The revelation comes just a day after Wavy broke that Corey Bigsby had been indicted by a grand jury earlier this week, and he had been deemed competent to stand trial. Bigsby's attorney, Amina Matheny Willard, declined to comment on the case on Monday. I think like kids have like this weird ass name and then they're just like, oh, I want to be a doctor or a judge or a lawyer because I can never pronounce these people's names. Bigsby has remained the only person of interest in the case, but hadn't been directly charged in relation to Cody's disappearance until Monday's indictments. He was arrested just days after 4-year-old Cody was reported missing and charged in connection to the alleged abuse and neglect of Cody and his 3 brothers after authorities said he left the young children home alone. That July, he was indicted by a grand jury on 23 more neglect and abuse related charges. Authorities, meanwhile, for months have presumed that Cody is dead, but a body has never been found. From the first minutes of the investigation, myself, the assistant chiefs, members of command staff were at Cody Bigsby's residence to see for ourselves what the evidence demonstrated. We have followed the evidence from day one. It was very clear to us the evidence about what likely occurred has been very clear. There is little about this that has been mysterious, said former Hampton Police Chief Mark Talbot during a February 10, 2022 press conference. Chief Talbot also released the following statement to, is that like WAVY, following the new grand jury indictment? I don't know what WAVY is. The news isn't a surprise to me. I hope that today starts the healing process for the family and for those of us who found ourselves in pain for a child that we never met. New court paperwork also shows Bigsby is charged with concealment of a dead body. He is due back in court Wednesday. Oh, I didn't see that. I'm going to have to go look back for that. Yes, hey, Freeside. Okay, so that was Cody Bigsby. That's all I have for him. Now we're going to Madeline Kingsbury and her children's father, her ex-boyfriend, Adam Fravel, who is charged with killing her as they found her body a few days ago. So the state of Minnesota, county of Winona, Adam Taylor Fravel, date of birth 1/29/94, and then his address. The complainant submits this complaint to the court and states that there is probable cause to believe defendant committed the following offenses, and I have the probable cause. Count 1, charge murder in the 2nd degree, Minnesota statute, maximum sentence 40 in prison. It's a felony. The offense date was on or around 3/31/23, which is when she went missing. That on or about March 31st, 2023, in Winona County, Minnesota, Adam Taylor Fravel caused the death of a human being with intent to effect the death of that person or another, but without premeditation. Count 2, murder in the 2nd degree, maximum sentence 40 years. It's a felony. That on or about March 31st, 2023, in Winona County, Minnesota, Adam Taylor Fravel caused the death of a human being without intent to effect the death of any person while committing or attempting to commit a felony offense other than criminal sexual conduct in the 1st or 2nd degree with force or violence or drive-by shooting. So he got charged with 2 charges of murder in the 2nd degree. Yeah. Oh, and Minnesota does not have the death penalty. I already checked that out. But we're going to listen to the press conference when they arrested him. I think it was. Let's see. View time. All right. Here we go. Hi, Jacob. All right, here we go. Tell me if you can hear it. Hold on one second. It's really low. Let me see. Hopefully
Good
they can
afternoon,
hear it.
everybody. Thank you so much for being here today. I'm Bonnie Bowman. I'm a public information officer with the Minnesota Bureau of Criminal Apprehension. We continue to assist in investigating this case. Today, you will hear from Winona County Attorney Karen Sonneman. She will offer some prepared remarks, and then we will have time for questions at the end. But as always, I do need to offer the caveat that this is an ongoing and active investigation. The prosecution is also just beginning, so there are some things we will not be able to discuss today. And we do ask that you respect and understand that as we get into the question portion of today's news conference. In the meantime, I'd like to invite up the county attorney.
Good afternoon. I'm Winona County Attorney Karen Sonneman, and I'm here today to announce my office filed charges against Adam Taylor Fravel for the murder of Madeline Kingsbury. Behind me is the team from my office and some law enforcement, but the team from my office that I have assembled to prosecute this case. This includes Special Assistant Winona County Attorney Phil Prokopowicz, who I have hired to lead our prosecution team. Mr. Prokopowicz is retired from the Dakota County Attorney's Office, where he served many, many years as the Chief Deputy in the Criminal Division. My team and I are committed to seeking justice for Maddie and her family. We have charged Mr. Fravel with second-degree intentional murder and second-degree unintentional murder. Some of you may be wondering why my office did not charge first-degree murder against Mr. Fravel at this time. Let me explain the law in Minnesota. In order to charge first-degree murder, a prosecutor must present the case before a grand jury, and the grand jury decides whether there is probable cause to support an indictment for first-degree murder. Because this case remains an active and ongoing law enforcement investigation, we may seek additional charges in the future. At this time, it's my understanding that Mr. Fravel remains in custody. The judge this morning set his bail at $2 million unconditional and $1 million conditional. His next court appearance is scheduled for July 20th, 2023 at 1:45 p.m. We know many of you are concerned for the well-being of Maddie's two children. They remain in Maddie's father's care and will stay there for the time being. The child protection case that my office is also handling remains open and active. A determination in that CHIPS or child protection matter will be made at a later date. We have heard from so many individuals how wonderful a person Maddie was. She had a bright future, and Mr. Fravel took that from her. By charging him today with her murder, we intend to hold him accountable to the fullest extent of the law. Thank you.
That ends the prepared statements. We're ready to take some questions again with that caveat that there are some things we just won't be able to share. So if you have a question, feel free to shout it out.
Ms. Sonneman, how do you think Maddie was killed?
At this time, I can only say that the investigation is ongoing and active, so I'm not going to make any comment about that at this time.
If Mr. Fravel does bail out, will he be able to see his children? Can you explain kind of how these two cases will work together?
Yes, a good question. There's also a family court custody case going on as well, which is, so there's really three proceedings. But in the child protection case, there were certain conditions in that case also where Mr. Fravel could have supervised and secure visitation with his children, meaning in a secure site, under observation, basically. If he bails out, the court allowed him to continue to have that supervision under those conditions that were in the child protection case. So that.
I plan on asking that to be revoked, though.
There is a later hearing in the child protection case, and I can't comment at this time on that, but all options are open.
Can you explain why there are two separate
there are two charges because one is called intentional murder and the other is unintentional murder. And at this time, as I explained, we can't charge first-degree murder, but we can charge those two. And based on the evidence that we felt we could prove with certainty from our perspective beyond a reasonable doubt, those are the most serious charges we can charge now. The difference between those is that the individual's conduct would be intentional to cause the death of a person. The other is that their actions unintentionally cause the death of the person.
Can you go into detail about more depth about the difference between intentional and unintentional?
Well, I would refer you to the Minnesota statutes, but it's basically just that a person had the intent to cause the death of another individual and took such actions that were intentional, and the result was that person was killed. Unintentional is just as it really states, that actions were taken and that person didn't really mean to have that, whatever the actions they did, they didn't really want it to result in a death, but it did.
Was Maddie abused? You talk about during the Zoom hearing, your special prosecutor told the judge about Fravel mocking officers, making flippant comments. Could you share a little bit more light on some of those interactions?
I won't go into great detail, but what he was referring to was when as part of the child protection proceeding, the children were, he had the children, and as you can, if you've read the complaint, and please read the complaint because it's very detailed, it'll answer a lot of your questions. But as we put in the complaint, he went and took the children from the daycare and brought them to his parents' house. So at the time the child protection case was initiated, the children were with him in his parents' house in Mabel, Minnesota. And so part of the child protection case was that Winona County was taking custody of those children. And so social workers and law enforcement went to secure the children, and that's where some of those behaviors were exhibited by Mr. Fravel.
Was Maddie controlled? And
Just she's go ahead.
Sure. In the press conference yesterday, you mentioned digital evidence that helped you locate Maddie's body. Is that the video footage that was outlined in the complaint, or was this something different? And so can you describe a little more?
Well, and I think I didn't say that, Chief Williams.
Sure, sorry. I see him standing.
Yeah, but at this time, again, I can only say that this is an ongoing and active law enforcement investigation, and we have just started our prosecution. So
there are instances in the complaint that refer to this. Was Maddie controlled and abused during their relationship by Adam Fravel?
Again, our case is ongoing as far as law enforcement investigation, and what's in the complaint is what's in the complaint. And again, this is just the beginning of this case, and there's more investigation to do. But there may be additional charges, but again, first-degree murder can only be obtained through a grand jury proceeding.
Well, what happens after July 20th?
It depends on what happens on July 20th. So, okay, so.
Any time for a couple more?
You can share.
In the complaint, it mentions that someone met the abstract description has pencil license plates on Adam's man. Can you confirm this was him? And was he switching? What was he doing with the license plate?
As the complaint indicates, we stated it was an individual that was observed changing license plates, and those are the type of issues that we would want to identify if this case goes to trial. So,
did he go straight to the spot where the body was eventually found, or did he go to the farm first? And there's an unaccounted for 45 minutes, it says.
Again, our case and law enforcement is an ongoing investigation. It's still active, and those are issues that I can't comment on now.
Did additional charges come out of Fillmore County in terms of possibly moving the body, concealing it?
I'm sorry, what?
Additional charges in Fillmore
Again, this is an ongoing investigation. I'm sorry I keep having to say that, but I don't want to compromise the integrity of either the law enforcement investigation or our prosecution case.
And that is
Thank
all we
you.
have time for today. Thank you so
Thank-
much.
thank
I
you.
do want to clarify, though, Lou, to your question, it's in the charging document, but the medical examiner's office did rule that the manner of death was homicidal violence. So it is in the charging documents. If you have read those, if you haven't, I highly suggest that you do. It adds a lot of context as to why these charges were presented and some more context to the case as well. And just for myself on a personal note, I want to thank you all for being out here. I know for many of you, it's a decent drive to get out here to Winona, and we really appreciate your continued coverage of this case. It has made a really big difference in keeping up the confidence and the spirits of the community as we continue to work through what is a really difficult case and prosecution and ongoing investigation, as we've said. So thank you again so much all for being here.
Thank you all.
Okay, guys. I know I was supposed to go through all this last night, and it's like a day or two old. So if you've heard all this already, I'm sorry. But we're going to go through the probable cause affidavit. And if you haven't heard it yet, hold on a second. I have to put a trigger warning. This is horrible, you guys. So horrible. I'm pretty sure it's big. Yeah, it's big letters. So you could probably read it if you want to read it. Okay, let's see. Statement of probable cause. On March 31st, 2023, at approximately 8:20 p.m., the Winona Police Department was contacted by a person who identified herself as a friend of Madeline Jane Kingsbury, date of birth 6/1/1996. That's when I graduated high school. The friend reported to police that she was concerned with the health and safety of Madeline. According to the friend, Madeline had not attempted to contact or communicate with her throughout the day, which the friend indicated was unusual. The friend was concerned and had gone to Madeline's residence, saw her minivan in the driveway, and knocked on the door. No one responded. The friend also told police that she was aware that Madeline was having issues with her significant other, who also lived at the residence. The friend identified the significant other as Adam Fravel. Winona police officers met the friend at Madeline's residence, located in Winona County, Minnesota. An officer knocked on the door of the residence and looked in the windows. No one responded, and the officer did not see anyone inside. Shortly thereafter, officers spoke with Madeline's father on the telephone and learned that her family had also not had contact with her that day. The father reported that it was uncharacteristic for Madeline to not have contact with family members or friends. A Winona police officer spoke with Adam Taylor Fravel, date of birth 1/29/94, by telephone. According to Fravel, he had not heard from Madeline since early in the morning, that she was supposed to pick up their children at their Winona daycare after she finished working, but she did not. Fravel stated he picked up the children at the daycare and took them to his parents' residence in Mabel, Minnesota. Later that evening, officers were able to conduct a welfare check inside the Winona residence and determined that no one was inside the residence. He took his kids an hour away from Winona to Mabel. After daycare, he traveled an hour away, dropped the kids off with his mom and dad, came back an hour to Winona. That shows suspicion right there. Law enforcement investigators have spoken with the children's daycare provider, who confirmed that both Madeline and Fravel were present when they dropped their children off at daycare on the morning of March 31st, 2023, at approximately 8:05 a.m. The daycare provider also stated that Fravel was alone when he picked the children up at the end of the day. On April 1st, 2023, law enforcement investigators obtained a search warrant for the Madeline Fravel residence in Winona. The interior of the residence was cluttered, but there did not appear to be overt signs of a struggle. During the search, law enforcement officers located what investigators later determined to be Madeline's cell phone, jacket, and purse in the residence. Investigators also located a laptop computer that investigators later determined Madeline used to work from home. Investigators later obtained access to the cell phone's databases. It was determined that a text message was sent from the cell phone to Madeline's sister on March 31st, 2023 at 8:15 a.m. Investigators noted that there were no subsequent text messages or calls sent from Madeline's cell phone. Law enforcement investigators had followed up conversations with Adam Fravel on April 1st and April 2nd. During these conversations, Fravel told investigators that he had met Madeline at college in Winona and that they had an on and off again relationship for the past 7 years. Fravel stated that they have 2 children, ages 5 and 2. Fravel indicated that Madeline worked from home and in Rochester, Minnesota. Fravel stated Madeline would generally travel to Rochester for work on Mondays and Fridays. Fravel acknowledged that Madeline was the primary income producer for the family and she would forward him money electronically to pay the family bills. What? Fravel acknowledged that recently their relationship was not working, so they decided to separate and were in the process of moving out of their Winona residence. Madeline had been looking at different apartments in the area for her and the children to live in. Fravel indicated that about 2 weeks ago, Madeline had told him that she had begun a relationship with another man, but that he did not know how long the relationship had been going on. Fravel stated that on Friday, March 31st, 2023, together he and Madeline dropped their children at daycare at around 8 a.m. and they drove home. Once they arrived, Madeline stated that she had an online meeting and afterwards was going to Rochester for work. He indicated he observed Madeline go downstairs to her home office. Also, during the conversations, Fravel stated he had planned to do property storage runs most of the day. His plan was to travel to his parents' home near Mabel, Minnesota, with items he wanted to store at his parents' residence, and return to Winona and take items to Midwest Storage, located in Winona. Fravel indicated that prior to leaving for Mabel, he had stopped at a gas station near his Winona residence. He said that when he loaded up Madeline's van, he wasn't really paying attention to what he was loading. Fravel believed he left his residence and began driving the van to Mabel at approximately 10:15 a.m. Fravel continued with the following information. Fravel stated that when he got to Choice, an area in Fillmore County, these city names, he started thinking about what he was going to do. He said he looked to the rear in the van and realized the items he had were meant to be stored at the storage unit, not his parents' place. He turned around the driveway of a barn in Choice and drove back to his residence in Winona. Fravel believed he arrived at the residence at about 11:30 a.m. and emptied the van at the Madeline Fravel residence. I wonder if where she was found was anywhere near that city Choice. When he entered the residence, he did not see Madeline. He stated he did notice his car was still home and thought that Madeline may have carpooled to Rochester. Fravel stated he remained at the residence for the remainder of the afternoon. During this time, he texted Madeline but never got a response. Eventually, he went downstairs and Madeline was not there. He stated that he texted Madeline regarding picking up the kids and asked about plans for supper. When she did not respond, he decided to pick up the children at daycare and drive them to his parents' residence in Mabel. Hold on 1 second. Let me take a sip of drink. Okay. Man, listen to this part if you haven't. Also, during their conversation with Fravel, law enforcement disclosed to Fravel a concerned persons report that Fravel told Madeline that if she did not listen up, that she would end up like Gabby Petito. Fravel admitted being infatuated with the Gabby Petito case. Fravel also admitted that he made a statement to Madeline about her ending up like Gabby Petito. Fravel claimed he was trying to make a joke. The Gabby Petito case made national news. It was the story of a 22-year-old woman who went missing. After extensive searches, Petito's remains were found near a park in Wyoming. It was reported Petito died of strangulation. The media also reported that Petito's fiance claimed responsibility for her death in a notebook. Investigating officers spoke with a friend of Madeline who indicated that sometime in 2020 or 2021, she was on a video call with Madeline, who was at her Winona residence. Madeline was standing up, holding one of her children and cooking dinner. The friend observed Fravel enter the room and yell at Madeline to keep quiet. Madeline asked Fravel to calm down, and he stated he was not going to calm down and struck Madeline in the face with his hand. It appeared that Fravel was not aware he was being observed on the video call, as when the friend yelled at Fravel over the video call, he immediately left the room. The friend told investigators that there were several times during video calls that she observed bruises on Madeline's face. When the friend inquired about the bruises, Madeline would cover them with her sweater. Investigators spoke with a family member of Madeline's. During that conversation, the family member discussed an earlier incident. The family member said she learned Fravel put his hands around Madeline's throat. The family member went with another person to go get Madeline. The family member noted Madeline had a red mark on the side of her neck that day. Pursuant to search warrants, investigating officers conducted forensic extractions on 2 Apple iPhones believed to belong to Madeline. A review of the forensic extractions of those 2 phones revealed Kingsbury as the owner and user. There were messages as well as screenshots of messages between Madeline and Fravel dating back numerous years. Ooh. One screenshot taken on September 21st, 2021 contained the following iMessage conversation between Madeline and Fravel. Trigger warning. Maddie, you know I'm not really okay with or over the fact that you put your hand around my neck and pushed me down in front of the kids earlier, so don't. Maddie, not okay with it all, but especially with them there. Fravel, you'll adjust. Maddie, the fuck I will. Maddie, you do that again without asking me and you can go somewhere else. Fravel, you got it, mother. Maddie, don't patronize me, that crossed the line. Fravel, then mind. Maddie, stop. Law enforcement investigators were able to obtain video from security cameras and motion detection videos devices at multiple residences and businesses located in the Winona neighborhood where Madeline Kingsbury and Adam Fravel resided. And along the route, Fravel stated he took towards his parents' residence the morning of March 31st, 2023. The videos reveal the following events from March 31st, 2023. At 9:44 a.m., Madeline's van is observed in the driveway of the Madeline Fravel residence in Winona. A person in a light-colored coat is observed walking up to the front of the van, bends over, and appears to remove the front license plate on the van. 9:47 a.m. The van is still in the driveway, and the same person is observed kneeling in front of the van and appears to be reinstalling a license plate. 9:55 a.m. A person wearing a light-colored coat or sweatshirt gets into Madeline's van while it is parked in the driveway of the Madeline Fravel residence in Winona. 10 a.m. The van is no longer at the residence. 10:02 a.m. The van is observed parked at the gas station where Fravel said he had gotten gas, and a person wearing a light-colored jacket and matching the general description of Adam Fravel is observed pumping gas. Investigators also noted that the license plate on the van matches the license plate registered to the car Fravel normally drives and not the plate registered to the van. Investigating officers noted that when they observed the van later in the evening on March 31st and on April 1st, 2023, the license plates registered to the van were back on the van. The van is observed backed into the driveway at the Madeline Fravel residence in Winona. Oops, that was at 10:31 a.m. 11:26 a.m. The van is observed driving away from the residence. Didn't he say he got back at 11? A van matching this 11:44 a.m. A van matching the description of Madeline's van is observed traveling southbound on Highway 43 in the direction of Rushford and Mabel, Minnesota, 11:56 a.m. A van matching the description of Madeline's van is observed traveling southbound on Highway 43 in Rushford and in the direction of Mabel. Okay, I guess that continues. 11:59. A van matching the description of Madeline's van is observed traveling southbound on Highway 43, south of Rushford and in the direction of Choice and Mabel. So Choice must be on the in between Winona and Mabel. Approximately 45 minutes later, a van matching the description. Oh, this is at 12:44. I am sorry. Approximately 45 minutes later, a van matching the description of Madeline's van is observed on a video from the same location, traveling northbound on Highway 43 in the direction of Rushford and Winona. So 45 minutes, 12:47 p.m. A van matching the description of Madeline's van is observed traveling northbound on Highway 43 in Rushford. 1 p.m. A van matching the description of Madeline's van is observed traveling northbound on Highway 43 and turned east onto Winona County Road 12 in the direction of Winona. At 1:28 p.m., a van matching the description of Madeline's van is observed in the driveway of her Winona residence. As part of their investigation, law enforcement officers traveled the route Fravel stated he drove on the morning of March 31st, 2023. Investigators noted that with the exception of the 45-minute time period between the time he is observed traveling south of Rushford on Highway 43 and later at the same location traveling northbound on Highway 43, the times are consistent with normal expected travel times between the locations. On June 7, 2023, a deputy with the Fillmore County Sheriff's Office was searching a rural area in Fillmore County next to a public gravel road approximately 1 mile from Highway 43 between Choice and Mabel, Minnesota. Investigating officers learned that this property had been routinely maintained by one or more Fravel family members. This property was also near the residence of Fravel's parents. While searching the property, the deputy located human remains in a culvert adjoining the gravel road. The remains had been wrapped in what appeared to be a gray fitted bedsheet that had been closed with black Gorilla Tape. Investigators noted that during a previous search of the Madeline Fravel Winona residence, they observed a roll of black Gorilla Tape that appears to be same color and width as the tape found on the fitted sheet that Madeline was wrapped in. Investigators also noted that the gray fitted sheet appears to be some bedding at the Winona residence. Additionally, the air mattress from the Winona residence was missing a fitted sheet. On top of the air mattress without a fitted sheet were pillows that had gray pillowcases. The human remains were transferred to the Southern Minnesota Regional Medical Examiner's Office in Rochester, Minnesota. The medical examiner's office identified the human remains as Madeline Jane Kingsbury from dental records and tattoos. The medical examiner noted that a knotted towel had been wrapped around Madeline's head and neck. The medical examiner's office performed an autopsy. A preliminary autopsy report determined the manner and cause of death as homicide and homicidal violence. Pursuant to Minnesota Statute 609.43, intentional failure to appear for duly scheduled court. Oh, that's not even. Yeah, it's pretty fucked up. Sorry, but it is. And it just pisses me off. Okay, I'm sure it does y'all as well. Sorry, but I have a potty mouth. So, okay, on to Lori Vallow. Let's see. I need to get a desk instead of this bed because it keeps squeaking and stuff. Okay, so for some reason, let's see. View tab. All right. For some reason, this first page is like small. You see that? And then like the rest are big. See that? Let me see. I'll have to try and make it bigger. Let's see, y'all. And then I'll have to minimize the other pages. Okay, so I saw this And it kind of, I mean, it makes sense. I know a lot of people are upset about it, but it makes sense. And it is what it is. So this is the order on victim impact statement, State of Idaho versus Noreen Vallow. I don't think this is long. Oh, maybe it is. So it says on May 14, 2023, a jury returned a verdict finding the defendant. Okay, this is all going over. Oh, well, it's saying she was charged, found guilty of all charges. So she's going to be sentenced July 31st, 2023. Now, at that hearing, Brandon Boudreaux and Larry Woodcock are not able to make a victim statement. A lot of people are upset about Larry. However, Kay is blood to Charles and to JJ. Larry is by marriage, and that's the difference. And that's why the judge is not letting Larry read one. Also, I heard that he's also not letting Tammy's sister or aunt make a statement either. I'm not gonna read all these pages because it's basically saying what we already know. But right here it says, I'll just read this part right here. This is what the court defines as immediate family members: a parent, a mother-in-law, a father-in-law, a husband, a wife, a sister, a brother-in-law, a sister-in-law, a son-in-law, daughter-in-law, or a son or daughter. Okay, so in this instance, Larry will be able to make a victim's impact statement for Arizona after Lori gets sentenced in July, and gets turned over from county jail to state prison. Then she's getting transferred to Arizona, and she's going to stay there until she goes to trial for the murder of Charles. Then that trial, he should be able to make a statement because it is Charles's sister and brother-in-law. See what I mean? This was only about the kids and Tammy. And he's not blood to any of the kids. So that's what makes it different. So I just want to show you that there will not be cameras request to obtain approval to video, audio record, broadcast, or photograph a court proceeding. Okay, so it's the state versus Lori Vallow. I hereby request approval to video, audio record. Case number CR 22-21-1624, as if we didn't hear that enough. July 31st, 2023, 9 a.m., Fremont County Courthouse, Judge Stephen Boyce. And it's signed by Lisa Smith, a Standard news organization, Standard Journal. The court denied it. The court, having considered the above request for approval under the Rule 45 of the Idaho Court Administrative Rules, hereby orders that permission to broadcast the above hearing has been denied. Does it surprise you? No, it doesn't surprise me at any. see, 14, 13 pages. Let me see how long it's been. Oh, 45. Okay, yeah, I'm not going to read all this. It's 15 more pages, and I'm not doing that this time. The state of Idaho versus Lori Vallow. This is for the state's objection and memorandum response to defendant's motion for a new trial. So it's just prosecution sending in why they believe that she does not need a new trial. It really is long. I'll save it and read tomorrow, but if you want to, but if not, then yeah, I'm not gonna read it. Y'all can't even see it, can you? Yeah, okay. It makes you mad, Kaz, but do you understand the reasoning behind it? And I'm sure everybody done saw Bryan in court, but we're going to watch it. So is court really an hour long? Hello, everyone. Please hit that like button for me. Great minds think alike, Kaz. Okay, is court really an hour long? It says an hour. Let's see. Let me share screen. All right, let's go. No, I'm not putting it on my TV. Hold on. I pressed the wrong freaking button. Are you kidding me right now? Big. Thank you. Okay, here we go. Tell me if you can hear it.
Thank you very much. Please be seated. And eat. Thank you. Okay, please be seated. Thank you. Here.
Didn't they have sound issues last time? I do vaguely remember they had audio problems last time.
Okay, so let's get on the record, please. We are now on the record. This is State versus Bryan Kohberger, CR 29.
It's really low. Can y'all hear it?
05. We're here for a hearing on the Gonzalez family's motion to appeal, amend, and/or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine. They did. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Kohberger is in the courtroom, represented by Ms. Taylor and Mr. Logston. And I believe Mr. Gray is, there he is.
Let me sit back here, Your Honor.
And I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonzalez family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of the names, Kaylee's name and Zayna's name. And I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that and wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right. And under Rule 11A1 of the Idaho Criminal Rules, this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website, and it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
If you allow me just a minute or two to get sorted out here.
take your
Appreciate
time.
it. Thank you.
Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. So for some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties ascribed above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared, but only having a 3-hour notice to allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case or any attorneys that might have an interested party in this case. So that's where we are today. I filed the motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as.
Can I interrupt you?
Yes.
There's no dispute about that.
Okay. Then
Your clients are not parties. The only parties of this case are the state and Mr. Kohberger. That's
okay.
And that's clear. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tapp case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Varner versus Delahunty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Slop was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Marshall, Maxwell is a trial publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says that.
Can I ask you a question about that? Because I mean, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
and I can address that, Your Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted, we received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family as well as myself. The other thing is that if the victims can say whatever they want the free speech, and that's exempt. Why would I not be allowed to say the same thing that they said?
My understanding is that your clients are not restricted in any way, never have been.
Well, and I'll give you an example.
I mean, is that true?
That's right. Well, I agree now, because that's not the tone of the Zoom meeting.
Well, we're not talking about the
Okay.
tone. I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I asked for clarification, now I understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, my victim, the family asked, has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion? Right? Well, then I'm already governed by the Idaho rules of professional conduct. And if
I'm glad you're acknowledging that.
no, well, every attorney is, Your Honor. I mean, it's not,
Thank you.
every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the trial publicity. But the trial publicity, I don't even think applies to me in this anyway. Because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3. The rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this: rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what it is.
You've been on the media and you've had interviews. So I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that they could explain things, say, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially, we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way. It's just an attempt to shut the attorney up and shut the family up, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So
Well, I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know
Well,
until the trial.
and the other thing,
Okay, well, let me just say this. I think one of the potential issues is, this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. Now, that is not post-conviction technically, is it?
Well, if your goal is fair and impartial jury, right, that's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. In this hearing is about.
And as an officer of the court, I can tell you we have zero access.
Okay, so you're saying that the prosecutor's office has not shared information with your client.
Regarding the facts of this case, no, they haven't.
Right.
How things occurred.
And everybody's gonna have a chance to weigh in on this, and I just, you're helping me understand what the issues are, so thank you.
What is, so that's really the issue here. I mean, and this is an important ruling, because what you're doing is this has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened, that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that, part of the argument is that,
In fact, I know I have the authority to do that.
well, and the authority would be through your the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay,
So
that's hard to accept, but.
We're not witnesses in the case, we're not involved in the investigation, we're not involved in the litigation. I can't file any motions, I can't subpoena anybody, I can't cross-examine witnesses, I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is.
We're talking about your
That's right.
speech.
That's right.
Not your client's speech.
But that is my speech, that is part of it though.
Well, in your memorandum, you are suggesting that you also have an independent position, that you are representing yourself.
I do.
It's distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said the judge, we thought the judge was crazy, and I said the judge was crazy, I can't be, that doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice where I said the judge is crazy. Yeah, I think the judge is crazy. That goes into another layer, right? Where it would be, Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradite those statements. And I may or may not fall under the trial publicity. I would argue that I don't, because I'm not a party to it. I'm not litigated it, I don't have any information on it, none of those things. So really, that's where the authority for me, for my voice, would come from the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for you, for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside, they interview him, they say, hey, you're an attorney here. What about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him and contempt of court? You can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho Rules of Professional Conduct by commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this, what potential witnesses are we, number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I could go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for Your Honor. I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked up, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they'd never interviewed us. So they're throwing stuff in the air that is not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Good.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Rattler.
Don't be me. Can I have one moment, Your Honor?
Certainly. Thank you.
If I may,
Yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and to the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we provided more information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients, and that somehow that is the investigator's fault. In fact, From the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you.
If I could speak to that, Your Honor.
You'll be able to
Thank
come
you.
back in after you hear the other
Thank you.
arguments. Mr. Redler, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Gray's repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonzalez families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepard, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. With that, I'll stand for questions.
Thank you, Mr. Redley. Yeah, do you think that would be helpful to just, and I asked Mr. Gray this same question, would it be helpful to say, okay, you say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
All right. Can you go back? You mentioned this about the standard, particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up, click here.
That's fine.
That the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepherd to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Thank you, Mr. Evans.
Thank you.
Judge, I think a lot has already been said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case and therefore don't fall in 3.6, would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation, and therefore you fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just, does it fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. We also agree that at this point, the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak. The media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's just trying to put the media into a frenzy and send this case to the firing squad or Calgary or something like that. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen prosecutors try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that. Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel express.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have made no contact as far as investigating and interviewing the victim's families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
It seems like you're in the court right now.
Because you're the one that brought me in here because of the non-dissemination.
You brought yourself.
Yeah, well,
you're the one who filed the motion.
I did file the motion because the non-dissemination order is unconstitutional.
I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why would you say that?
Well, because I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once again,
well, the Supreme Court has said they have standing to come into the court and address issues. So
yeah, but that's completely separate. They're not.
Well, I know it's separate.
Okay, so
I also respect your position in representing the family's victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. They had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it will hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case. And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this. In the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way, and they've never taken this up. And maybe a random email here and there that says something and no follow-up whatsoever about anything. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the
the information that has been disseminated to the public from the get-go was the mayor, our deputy. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between
That's
the state and Mr. Kohberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that that was stipulated by all parties. I never stipulated to that. I emailed the
You're not a
judge.
party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties. As
So,
you've correctly stated who the parties are.
so we would
I
ask,
agree, but you were suggesting that it was entered to shut down the prosecutor's office.
why would they
That's what
claim?
you just said.
I do think that part of the, that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
When you say they, you mean the prosecutor's
Yes.
office.
Yes.
All right.
Do you want me to give you a final, or do you?
Go fight.
Okay.
You go.
We're not a party to the case. You're very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule on the Idaho Rules of Professional Conduct, because I'm not litigating it or party to litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply, Your Honor. Thank you.
Okay. Thank you, Mr. Green. All right. Well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today. And I'll get back to work and try to get a decision out as soon as possible. So, anything else we need to address before I adjourn? Mr. Thompson?
I don't think so, Your Honor.
Ms. Taylor? Mr. Watkins? Anything else?
Yeah, PR, we thought you'd probably want to issue an order and wait, but I guess we're just wondering if in the meantime, the order as it is remains in place.
Yes.
Thank you.
It remains in place until I address it. So, with that, we are adjourned. Thank you all.
I remembered to unmute myself that time. Okay, it's been an hour and 40 minutes, so I'm going to go. Thank you for watching. Have a nice day. Bye.